the Section 4 point, the plurality of Section 4's, if you give Section 4 of the Immunities Act the simple, clear, encompassing interpretation which we say it has, that you will not be in bad company. There is a case which we gave to our learned friends yesterday. We'd ask to hand up to you now, if we may. We appreciate the court has had too much paper, but it is a Supreme Court of Canada judgment, 2014, and it holds in particularly precise terms that its Act of Immunities, and it had an Act of Immunities, covered anything which was conceivable in terms of the most egregious torture and the like. It was a civil proceeding, in fact, brought against the government of Iran and the Ayatollah Khomeini. And we commend to you the one flag passage in that judgment, if we might just hand it up to you without further comment. Oh, I'm sorry. The name of the case is Kazemi, is K-A-Z-E-M-I, estate of the late Zara Kazemi, versus Islamic Republic of Iran, Ayatollah Ali Khamenei. And its references 2014 SCC 62. It is a court not given to writing briefly, but the passage we refer to is a very short one. We say the point is whether it's civil or criminal jurisdiction, there is a Supreme Court that says it's entirely consistent with what has to be done to say that for the reasons we've argued at length, immunity must be held to be encompassing immunity, unaffected by any other consideration. May I also hand up that threatened article, very short in this instance, by Professor O'Keefe of the University of Public International Law at University College London, where in vigorous terms he refers to the attempts to suggest that international law is poised to do anything significant in this regard. No, he is a true internationalist, Justice Lewis. He writes about international law, and very briefly and usefully, I believe, to members of the court, would give you a very succinct update on the position. Professor Dugard was understated, or perhaps optimistic again, when he suggested it was poised in any direction, or the direction that he indicates. Justice Lewis, then may I deal briefly with what is the second leg of the case, the Section 5 aspect, the ministerial notice. In that regard, the Genocide Convention gives rise to the same well, we've addressed it in our heads of argument, but it's the same position we respectfully submit, that you have the Immunities Act, which legislates for the field, and the Genocide Convention, Sudan's accession to it, does not have any consequence as regards the privilege which accrues to its sitting head of state for the requirements which I've already addressed of our own act. Not express, not in writing, not a waiver.
Well, I ask that because it seems to me that the case that you cite, Regina versus Bowes Street Magistrate, the speech by Lord Phillips seems to indicate that in the case of the Genocide Convention, it amounts to a waiver. And specifically at 189, they refer to it, I think one of the amicus curiae referred to it.
That is, with respect, not our understanding, but might I look at that, Justice Majid, if necessary, pick it up?
It's at 189, and it's the portion that starts with where states by convention agree that their national court shall have jurisdiction and so on. And then it says that the Genocide Convention removes an immunity by express agreement or waiver.
Yes, may I just give one short answer to that and come back to it if it's necessary? Throughout, SALC fails to distinguish between immunity ratione materiae and ratione personae. Yeah. Lord Phillips is dealing with ratione materiae in that judgment.
Except that in this passage, and that's why I want you to have a look at it, He specifically refers to ratione personae.
Well, thank you, then I will look at it again. But yes, there we are. May I deal with section 5? And say that the point is simply that the notice incorporates, which is at page 42 of the record, and also at pages 101 to 2, incorporates by reference, as you know, what appears at page 92 in relation to section C, representatives of member states. And it includes specifically immunity from personal arrest or detention. And that in item 6 on page 94, the expression representatives shall be deemed to include all delegates, deputy delegates, etc. The president of Sudan was a delegate of Sudan. The attempt to construe the ministerial notice as a matter of interpretation as according an immunity only to African Union representatives in the sense of staff, etc., is not right by virtue of that incorporation by reference, and it would be improbable, implausible, if one considers what clearly was being intended. So we respectfully submit that as a matter of interpretation, it has that effect, and after that, there is no word from the other side, if we are correct on that they have a capacity to brush it aside in light of Odekral and Kurland. So for those reasons, we submit that we should succeed on that separate basis.
As a ground of immunity, do you, Mr. Gortley? You simply say that because the proclamation hadn't been set aside, it stood.
Absolutely, sir.
Are you suggesting that on its terms, that proclamation, read with the agreement, conferred immunity on President al-Bashir?
That's just what I've argued, Justice Wallace. The argument is...
Are you serious? Where do you find that?
I find it in the notice, and I'm sorry to repeat. Yes.
It refers to delegates.
Yes.
It doesn't refer to heads of state.
Well, then let me retrace my footsteps. If one...
The entire agreement with regards to this notice
yes.
is to facilitate the organisation of the African Union's conference,
yes.
is it not?
Absolutely.
At South Africa's expense.
Exactly.
Yes.
And to that end, requiring the presence at the summit of the heads of state. And what you find in paragraph 1 is the reference to delegates and other representatives. The word delegates we underline, because what happens is our learned friend suggests that that should be treated without reference to the almost definition section which follows 3 lines later, section C and D, articles 5 and 6. And if you go to delegates and dealing with the immunities at the pages which we referenced in the record, which is 92, including specifically representatives of the member states, coupled with the definition then in item 6. We say...
Delegate to the assembly, as opposed to attending by right, by virtue of Sudan's membership of the AU as its head of state. Where does it say he's a delegate? Within the meaning of that expression, as it is used in this document.
The answering affidavit at page 51 onwards invokes the host agreement.
Yes, well, the government has relied entirely on this
yes.
notice and the agreement,
yes.
And has not dealt, as you have indicated, with section 4, which you would think would be the primary argument.
Yes.
But it doesn't anywhere state that a head of state is covered by this particular agreement or by the government notice that followed.
In its affidavit, Justice Wallace, I don't see that. But what I do see...
Nor did I.
No. But then it's a simple approach. Either the court holds that in the circumstances I've described, that where a reliance on the notice and the agreement is placed, I'm getting my prepositions are going awry, placed upon in the answering affidavit, the matter is argued before the High Court on the basis that it covers the President to such an extent that the High Court rather loses its way and forgets about Section 4 and deals with Section 5. That on some fastidious principle applicable to this kind of urgent litigation, I am disabled from contending on appeal, that as a point of law on these documents, the President of Sudan is encompassed as a delegate. And we submit that the court would not do that. If the court holds that by virtue of the affidavit produced and filed on a Sunday afternoon or early Monday morning, that because there's not a sentence which says the President of the Sudan is a delegate, when that was the issue, clearly asserted, argued, and covered by the documents we put up.
Yes, it's not just the answering affidavit that's lacking, it's the agreement itself and the notice.
Oh, no, well, that's a different point, and we say that either I'm right or wrong, that the notice has an umbilical cord, quite express, going into what it references. And if you go to what it references, it makes it quite clear that when it's incorporating it by reference in the notice, what Justice Lewis ultimately, with respect by paraphrase, is putting to me, would it be a different case if it said heads of state in the notice? I'm saying no, if I'm correct, that the notice refers to a document which encompasses heads of state by reference to the delegate point.
Mr. Baumfit, I don't want to repeat myself, but again, one has to look at the purpose of the agreement and the ensuing notice, and that was to facilitate the hosting of the conference.
Yes,
not to give immunity to people charged with international crimes.
Well, we would respectfully submit that the purpose of the provision was not to protect, and I mean them no disrespect, but subordinate lesser officials, OAU functionaries, who are least likely, as it were, to be in need of any such protection. But I'm either right or wrong, that there is an umbilical cord, it is an incorporation by reference, and the wording includes delegates. Delegates of a country would be the Minister of Foreign Affairs or whoever, and in instances where it's the head of state, it's the head of state.
Can you tell us what is the document under which sessions of the Assembly of the AU are held? Because amidst all this mass of paper, I don't think anybody's bothered to give it to us.
Perhaps, Justice Wallace, because all parties were agreed it was of no relevance.
Well, maybe they're wrong.
Yeah, indeed, then that would be a loss of jurisprudence. So we respectfully then submit on either leg there is an immunity. I have argued that the recourse to the Security Council resolution does not create a waiver such as acknowledged by our law, nor does Sudan's position as a result of being a signatory to the genocide memorandum. I will revert to Justice Majid on his specific question, but we do stand full square by the proposition that all the law that we have seen and advanced does not accept that jurisdiction ratione personae against any crime, however heinous, has been lost to a sitting head of state as a matter of customary international law. Justice Lewis, I don't want to take up a particular time now dealing with the amici with your leave for these particular reasons. I want to say that we've endeavoured to put into our submissions filed heads which have sought to answer 3 points raised by the Helen Suzman Foundation. And we submit that, I don't know whether...
I was actually suggesting to my assistant presiding that perhaps we should be dealt with.
Well, that is exactly what I was contemplating doing with the court's leave. And equally, as regards the others, we have a few short points, but there really are points to be made in reply.
Let us let the amici and the hopeful amici make their points.
Yes.
And
Yes.
you may then reply to them.
I have one point on costs, and that is this, that if SALT loses, then it loses, we respectfully submit it gets no costs. If it, sorry, let me put it the other way around. If Buyer Watch would apply in ordinary circumstances in the relation to the bringing of important issues to the court, that we accept. We do say to you that there should be no entitlement under any circumstances to costs in relation to the application for leave to appeal. This case had to be heard by this court. It's a vital case. And we say the persistence, without arguing it in heads of argument and requirement, as this court requires, should result in the fact that in this court, costs in relation to leave to appeal, and we spent a quarter of our pages on it, and you've spent a lot of time, should be disallowed.
Yes, well, I think we should hear Mr. Trump.
Yes. Thank you, Madam.
Again, you.
Yes.
What does it mean?
Well,
It's not an order I've ever come across.
My learned friend is an expert in asking for complicated cost orders, but I understand it to mean
What,
119, the Lord say.
yes. The applicant is entitled to the costs of the application
Yes.
on a pro bono basis.
Yes.
What does that mean?
My learned friend would perhaps better explain than me, but I think as I understand it, it means counsel appear pro bono, but where they fly or drive cars and arguably sleep in beds, which are not their own, that would be encompassed by that. But my learned friend will state it more accurately if I'm wrong.
Excluding costs of appearance of counsel.
As
The incidental.
as the court is.
May it please the court. The question in this case is whether President al-Bashir was immune from arrest under South African law when he visited in June last year. We submit with the greatest of respect that that the answer to that question is simple, because it lies in section 10(9) of the ICC Act, which is clear and unambiguous. It says that the fact that the person to be surrendered is a person contemplated in section 4(2)(a) or B, which includes a sitting head of state, does not constitute a ground for refusing to issue an order contemplated in subsection 5, which is an order for the surrender of that person to the ICC. So it's absolutely clear. There is no ambiguity to it. It means what it says. And it speaks not only of former heads of state, but it speaks of someone who is a person contemplated, i.e. who is a head of state. My learned friend's only answer seems to be, well, it can't mean someone who is a head of state. It must be confined to a head of state who has waived privilege or waived immunity. But that's an absurd outcome, because that means that what the section says when it refers to heads of state is that a sitting head of state enjoys all the immunities conferred on him by customary international law, except if he's waived, or he or his state has waived the immunity, in which event he shall enjoy no immunity. That is a complete absurdity.
Well, it requires changing of both sections 4 and parts of
Same argument
section
goes to
10.
both of them,
Yes.
indeed. Not only does one have to change the language, but change the obvious sense of the section. It says a sitting head of state does not enjoy any immunity against surrender to the ICC. That's the answer to the question in the case. Not only does
Do
that...
you submit, Mr. Trengove, that the effect of the provisions of the Implementation Act is to take away the immunity of a head of state conferred by Section 4 of the Immunities Act when that person has been charged with the crimes contemplated by the Rome Statute?
It amends the prior section to the extent of their inconsistency. And insofar as the one says all heads of state have a certain immunity, and the other one says that a head of state charged with an international crime does not enjoy immunity, the latter qualifies the former.
Not necessarily incompatible. If anything, they dovetail quite neatly with each other.
Yeah, indeed. But there's, the point is that Section 4.1 of the Immunities Act cannot be invoked to defeat the plain meaning of Section 10.9 of the ICC Act. And that's the end of the case.
Well, it would defeat the purpose of incorporating the Rome Statute.
Indeed, my lady. And let me say, the outcome of that very simple reading, that very simple answer to the case, is a happy outcome, because it also gives effect not only to the Rome Statute, to which South Africa has subscribed, but it also gives effect to the ICC Act. And we refer in this regard to the quotation from the Constitutional Court judgment in the torture docket case that we quote at the top of our page 10 of our heads of argument, where the court said, "Our country's international and domestic law commitments must be honoured. We cannot be seen to be tolerant of impunity for alleged tortures. We must take up our rightful place in the community of nations with its concomitant obligations. We dare not be a safe haven for those who commit crimes against humanity." That goes all the more so for those who stand accused of genocide, of war crimes, and of crimes against humanity.
So your construction of the Implementation Act is this: if you're charged before a South African court, it's no defence to say I'm a head of state.
That's Section 4.
That's Section 4. If instead South Africa is performing its obligations to assist the court by surrendering, saying that I'm a head of state is again irrelevant. And the Act does not incorporate the Rome Statute. It attaches it as a matter of information. And Article 89.1 is not incorporated into the South African statute. Mm-hmm. Because 89.1 that has always caused this tension.
I think it's 98.1.
Oh, sorry, 98.1.
Yes. Indeed.
Sorry, 98.1, yes.
Yes. We have simply chosen to replicate Section 27, which makes it clear that it doesn't matter where or by whom these crimes are committed, but that there will be no place to hide. That philosophy, that purpose would be defeated by this very strange interpretation, which incorporates firstly the Immunities Act and through it customary international law, and moreover a very controversial interpretation of it. That is all very interesting, and I'm going to deal with it simply to demonstrate that even when one does, there is nothing in the Immunities Act or in customary international law that contradicts our interpretation of Section 10.9. But that is a negative purpose. One doesn't, the answer to the case is provided by Section 10.9, and one need go no further than that. I may just say I'm going to reserve the last 10 minutes of my allotted time for my learned friend, Mr. Du Plessis, who will speak about customary international law, of which he is much greater expert than I am. As far as the facts are concerned, may we just emphasize two things. My learned friend referred to the prior rulings of the ICC on the very issue before the court, and that's the immunity of President al-Bashir. And he suggested that there was a ruling given on a Saturday evening by a single judge sitting on his own and obviously opining on the South African situation. That is not correct. We mention at page 4 of our heads of argument, in paragraph 12, firstly the Congo case, where the ICC ruled in 2014 that the effect of the Security Council resolution was to strip President al-Bashir of whatever immunity he might otherwise have enjoyed under customary international law, and that there is thus an obligation under all ICC countries to surrender him if he set foot on their territory. So that's a clear and unambiguous ruling made a year earlier. And then, as we mentioned on page 5, at the time of his visit here, or shortly before his visit, the South African ambassador engaged with the ICC about his visit to South Africa. And it was again made absolutely clear to him that South Africa had an obligation under the Rome Statute to arrest and surrender General al-Bashir. That is dealt with in the ruling that we quote at page 5, and you'll see that ruling refers to the Congo judgment of a year earlier and the consultations with the South African delegates on 12 June. So it was emphasized to them that they are bound under under the Rome Statute to arrest and surrender General al-Bashir.
Well, Mr. Chingo, are you going to deal with the problem I raised with Mr. Gauntlet at the outset? That on my reading of the papers, all these fascinating arguments were not raised before the High Court. All that was raised there was reliance upon the AU agreement, the AU hosting agreement, and the proclamation. And in particular, for example, at paragraph 3.8, Dr. Lubisi, at page 107, says the Cabinet was fully aware that their decision only applied for the duration of the AU summit. There was never a rowing back from the position that had occurred when President Zuma was inaugurated, where the message to Sudan was, if he comes here, he'll be arrested. And the issue of arrest was never in issue below. The only question was there this immunity arising from this agreement? I know one of your learned juniors was actually there, but I'd be interested. That's my understanding of the papers. I would like to know if that is in fact what occurred.
That is also my understanding, but I'll check with the one of us who was there on that Saturday afternoon.
Sunday.
Because Saturday and then Sunday, Sunday and Monday, yes, indeed. Yeah. Now, if one then, but let me again say, all of this complication need not arise. It arises only because the government raises the complication and introduces the Immunities Act and customary international law.
Unnecessary for the purposes of law.
Quite unnecessary. My argument can stand or fall by section 10.9, and that's it. But if I may turn to the provisions of the ICC Act, the court has made it plain that the ICC Act explicitly in its preamble and its purpose sections makes it plain that its purpose is to domesticate the Rome Statute, so that it should be given an interpretation which gives effect to South Africa's obligations under the Rome Statute and makes them effective. The section 4.2 makes it clear that a head of state does not enjoy any immunity before the South African courts, and I quote, despite any other law to the contrary, including customary and conventional international law. So it's made absolutely clear that South Africa has opted to strip all heads of state, sitting and former, of whatever immunity they might otherwise have enjoyed under any other law, including customary and conventional international law. And let me say of that provision, we don't say that this provision is directly applicable because this provision, we accept, is concerned with criminal proceedings before the South African courts.
No, but it has to be read together with 10.9.
Indeed, the two are complementary.
10.9 means nothing without.
Indeed, the two are complementary, but we submit that the legislature adopted the same policy in the one as it did in the other. And the policy of both is that it doesn't matter who it is or where they committed the crime, they are liable to our jurisdiction, and we would not recognize any immunity.
And
South Africa is committing to bring those guilty of reprehensible crimes to book.
Indeed.
No matter their status.
Indeed. And what this section does is that it recognizes that there might be some controversy in customary international law, but what it says is that we have chosen, despite that controversy, not to recognize any immunity.
And then you read 10.9, because this is dealing with surrender to the court,
yes,
with the fact that when they get to the court under Article 27, when they say, but I'm a head of state, the answer will be that is irrelevant.
Exactly. Now we give effect,
as it always has been.
10.9 gives effect to 27.
Yes.
That is to say, because the court doesn't recognize any immunity, neither will we in discharging our duty to respond to ICC requests. And let me say, but while I am with Section 4.2, Justice Wallace, I submit with respect, firstly, Section 4.2 also speaks of anybody who is or was a head of state. It's again that clear language that makes it clear that it applies also to sitting heads of state. Our learned friend's suggestion that it only applies to a sitting head of state if his immunity has been waived anyway introduces the same problem I've addressed before. It's both nonsensical and requires a change of language. Our learned friends suggest in paragraph 54 of their heads that they seem to accept that when Section 4, which makes these international crimes punishable under South African law, 4.2 says nobody has immunity, 4.3 says and the courts have jurisdiction as long as the perpetrator is here. Now, our learned friends seem to accept that that means that a sitting head of state may be prosecuted, convicted, and sentenced to life imprisonment, but they say may not be arrested. Well, that is an absurd interpretation. Yeah, but that's what they suggest in their paragraph 54. The fact is that what 4.2 shows is that the South African legislature has chosen to make it clear that under South African domestic law, whatever customary international law might say, under South African domestic law, those accused of these international crimes do not enjoy any immunity at all, whoever they are, even if they are sitting heads of state. We describe from page 12 in our heads that scheme of the ICC Act to which Justice Wallace has referred, sections 8, 9, and 10. And if you follow that scheme, it prescribes 7 mandatory steps, each of which leaves no discretion for an inquiry into immunities of the perpetrator. I won't recite them now, but what is striking about them is that they say when the request comes from the ICC, it must be referred to the DG for justice. The DG must refer it to the magistrate. The magistrate must endorse it. 9.3 says it must be executed. When the when the suspect is arrested and brought before the magistrate holds that very simplistic inquiry that Justice Wallace identified. 3 questions only. If the answer to the 3 questions are the right answer, he must order the surrender. There is no room in that scheme for an inquiry into the defense or claim of immunity. And that is the scheme that then leads up to 10.9, which makes it explicit that it doesn't matter who it is, even a sitting head of state does not enjoy any immunity against this process. Again, a process entirely in line with the purpose of the Rome Statute. Now, our learned friends deal with section 10.9 in their heads of argument in from paragraph 55, but with respect, never provide an answer to the ordinary meaning, the plain reading of section 10.9, namely that it strips a sitting head of state from any immunity against an order for the surrender to the ICC. We deal with that argument in our heads of argument from page 15 in paragraph 35, but because my learned friend did not reiterate that argument in his oral submissions. I won't dwell on it. And you will see that in that argument that they make on 10.9, that they place pivotal reference on an article of a Mr. Gierwitz, who asserts that the Act is silent on the question of on the role that immunity plays in a request for surrender to the ICC. Well, Mr. Gierwitz just overlooked Section 10.9. It is impossible for him to have made that statement if he had known of Section 10.9. So that our learned friend's argument, based on Mr. Gierwitz, for the interpretation of Section 10.9 is wholly misguided because it is an interpretation of a man who overlooked Section 10.9. He clearly was not aware of it when he made those assertions about it. And that, with respect, means that at the end of the interpretation exercise of the ICC Act, one comes back to Section 10.9. It stripped President Bashir and people like him of whatever immunity they might otherwise enjoy. And we commend in that regard the scholarly conclusion, the scholarly endorsement of that interpretation by Professor Clady, whom we quote at page 17 in paragraph 36 of our heads of argument, because that is precisely also how he has read these
Was he not an advisor to the government?
That is why we quote him with such relish. He is also a discerning scholar who quotes Mr. Duplessis. We mention at the top of page 18 that this approach is not a unique approach. In fact, it is the recommended and common approach. It's the approach commended by Professor Kasesi, internationally renowned scholar and former president of the ICC, which says that the prudent approach domestically is to exclude any immunity claims at the domestic level so that it can be resolved at the ICC level. And it is common cause that that is also the approach that has been adopted by many of the members of the ICC. So that we would submit is really the end of the case. But we go on to customary international law, which we address at page 20. This is the topic that my learned friend Mr. Duplessis, which my learned friend Mr. Duplessis will elaborate. But let me say just 3 things about it. We accept that there is a general rule at customary international law that sitting heads of state enjoy immunity against prosecution in the domestic courts of foreign states. So we need not debate that proposition. We need not quote Professor O'Keefe, who says only that. That is accepted and it's irrelevant for our purposes, because the question is not here whether President al-Bashir should be prosecuted before our courts. The question is whether he should be surrendered to the ICC. We know that in South Africa,
the arrest case specifically distinguishes.
Indeed. In South Africa,
the Rome Statute was not yet in force, was handed down, but it is in the majority judgment expressly singled out as an exception.
The point, that is exactly the point. Even the bedrock of the argument for that immunity recognizes that there is an exception in favor of prosecutions of international crime before international tribunals. So the very rule, the very general rule on which our learned friends rely, have always allowed for, has since 2000 allowed for this exception in favor of international prosecutions of international crime. And so that when our learned friends quote O'Keefe or the Supreme Court of Canada to say that there is immunity at customary international law or under Canadian legislation against civil or criminal prosecution before the domestic courts, it's interesting but irrelevant to this case, this case does not concern a prosecution before a South African court. This case concerns the surrender of the suspect to the ICC for prosecution under for these international crimes. And there is just no learning to suggest that there is immunity against the exercise of that jurisdiction. We deal with the impact of the Security Council resolution from page 27 of our heads of argument, because we submit in the first place that General al-Bashir did not enjoy any immunity against surrender, whether under South African domestic law or under customary international law. But if he did, then he was stripped of that immunity by the Security Council resolution.
Yes, I have some difficulty in understanding that argument because of the terms of the Security Council resolution itself. It decides a number of things, refers Sudan to the Security Council, it encourages cooperation, but doesn't seem to do any more. And I'm not sure that one even needs to get there, given the interpretation of sections 4 and 10.9.
No, one doesn't. But insofar as one's opponent suggests that it's relevant, let me say this. It is paragraph 2 of the order. The order appears at page 201 of the SCA record. That's the application record. The Security Council resolution, I said. And it's paragraph 2 that is relevant. Well, let me read it with 1 because the two go together. 1 says the Security Council decides to refer the situation in Darfur since 1 July 2002 to the prosecutor of the International Criminal Court. And then 2, decides that the government of Sudan and all other parties to the conflict in Darfur shall cooperate fully with and provide any necessary assistance to the court and the prosecutor pursuant to this resolution. The argument is simply that, and that order is binding on Sudan. It's not binding on South Africa, but it's binding on Sudan. And the argument is simply, argument accepted by any number of international scholars, that the order that Sudan shall cooperate fully with and provide any necessary assistance to the court simply does not leave any room for Sudan to invoke.
What about the second half of that paragraph? I mean, why did they go on to say, while recognizing that states not party to the Rome Statute have no obligations under the statute, if that was not a recognition that Sudan is not a party to the Rome Statute? Surely that's the very thing they're saying is, we want you to cooperate fully. We recognize you're under no obligation to do so, but we urge you to cooperate fully.
Yes, but that would go for the rest of us, not Sudan.
Well, why would they put it in for the rest of us? They weren't thinking about the United States and India and Great Britain and Russia and China and other small countries that aren't signed on to the ICC. They were concerned with the fact that they were telling Sudan they wanted it to cooperate, and Sudan isn't a member, and it isn't bound. Surely yes, that's what the second half's about.
Justice Wallen, let me say, I do think that there are two parts to the paragraph, and let me just make clear that the first part is an express order on Sudan to cooperate, because it says it decides the government of Sudan and all other parties to the conflict in Darfur shall cooperate fully. Now, we would submit that we don't need to go any further than that, but let me just go then to the second part. Shall cooperate fully with and provide any necessary assistance to the court and the prosecutor pursuant to this resolution. And then it seemed to us that they then turned to the rest of the world, having ordered Sudan to cooperate. It says, and while recognizing that states not party to the Rome Statute have no obligation under the statute, urges all states and concerned regional and other international organizations to cooperate fully. So Sudan is ordered, the rest of us are urged. But whatever the second part might mean, we submit that the first part is an order on Sudan to cooperate. an order on Sudan to cooperate doesn't leave, a binding order on Sudan to cooperate, doesn't leave any room for Sudan to invoke immunity which would frustrate the prosecution of the perpetrators.
So there's no waiver of immunity.
No.
Sudan becomes bound on your argument by virtue of the resolution itself.
Exactly, my lady. And our learned friend's only argument was an argument that turned on the meaning of waiver under South African law. We accept fully that waiver might be, and that's a term used internationally, but under and it might be inappropriate to speak of it as waiver, as we know waiver as being an abandonment by the rights holder itself of its right.
You're talking about a removal of immunity.
It's a deprivation or removal or a stripping, but it's a superior authority that has ordered it to act in a way which doesn't allow it to invoke any immunity.
And why does this bind Sudan, which is, it's made under Chapter 7 of the Charter, of which provision of this Chapter 7?
Yes, we quoted it in our heads. I think it's Article 48 or 49, which...
some of the academics referred to Article 20, but I'm not sure that's right.
Let me just find it. No, I think we quoted it where we dealt with the facts.
I think you suggest because Sudan is a member of the UN, it is binding.
Yeah, you'll find it on page 2 and paragraph 5 of our heads of argument, where we say that the Security Council exercised that power under Chapter 7 of the UN Charter. That's the power that even allows armed intervention, and that Article 48 obliges members of the UN to give effect to the determination, and 49 adds that all members of the UN shall join in affording mutual assistance in carrying out. So it's Articles 48 and 49 that would oblige Sudan to comply. We deal with the Genocide Convention at page 33.
May I ask Mr. Chengo, do you or Mr. Duplessis or somebody else on your team have those conveniently to hand, because they are not included in your bundle of documents?
Which is that?
Articles 48 and 49.
We'll certainly do that. I think we have them here, but we'll certainly let you have them.
Okay.
We have nothing to add about the Genocide Convention because some of my learned friends for the amici will deal with it. But again, we submit that the express exclusion of immunity under Article 4 is unambiguous, and there's no reason, again, to give it a restricted meaning. And that would be another reason to conclude that President al-Bashir was not immune, at least insofar as he was being accused of genocide.
That's the second warrant. It's the second warrant.
Indeed, yeah.
Yes.
It brings us to the Immunities Act, which ultimately becomes the foundation on which our learned friends today contend that there was immunity. Now, may I say 4 things about the Immunities Act? Section 4.1, more particularly. Firstly, the point raised by Justice Wallace, and that is that it gives immunity from, quote, the criminal and civil jurisdiction of our domestic courts. We submit with respect that when a magistrate acts under Section 10, he does not exercise criminal or civil jurisdiction. He might be a court. It doesn't help for my learned friend to say, look at Section 10, it speaks of a court. He might be a court, but the function performed is an executive or administrative function of providing international assistance to the ICC in accordance with the ICC Act, so that we submit that the section does not even engage this exercise. But secondly, we submit that on
sitting as a court, how would you characterize the function being performed, though?
We submit that it is an administrative function or an executive function. As was suggested by Justice Wallace, it could as well have been performed by the DG of Justice.
It's because the magistrate has to make no decision. He's not faced with any choice.
It's an administrative decision. It's like a policeman who makes an arrest with a view to a prosecution. The policeman doesn't perform a judicial function. He arrests and surrenders to the court, who then performs the judicial function. In this case, the magistrate performs an administrative or executive function with a view to a prosecution, with a view to the exercise of the criminal jurisdiction of the ICC, not the criminal jurisdiction of the South African court. But secondly, we submit, even if the section is engaged, then we submit that on a proper reading of the section, it affords no greater immunity than a head of state enjoys under customary international law. And that is an immunity against prosecution in the domestic courts of another state. As we have submitted, my learned friend will explain, customary international law does not afford an immunity to heads of state for prosecution of international crime before international tribunals. So that even if the section applies, it would not immunize President al-Bashir against surrender to the ICC, because customary international law does not protect heads of state against prosecution before international tribunals. That's the exception recognized in paragraph 69 of the arrest warrant case in the first place. Thirdly, even if we're wrong on the first and second point, President al-Bashir has in any event been stripped of whatever immunity he might otherwise have enjoyed, in this case, by the Security Council resolution. In the fourth place, even if we're wrong on 1, 2, and 3, even if there is some immunity left under Section 4.1 of the Immunities Act, it is trumped by the ICC Act, Section 4.2 and Section 10.9. And we have addressed the reasons why it trumps the Immunities Act. It is so obvious. It is the later act, and it is the more specific one, dealing specifically with heads of state being accused of international crime.
But it's introducing an exception to the normal rule.
Indeed.
To the rule of customary international law that is embodied in the Immunities Act.
Indeed, that is so. So that we would submit that there is no joy to be had from Section 4.1 of the Immunities Act. It leaves, lastly, the host agreement. Well, whatever else one might say of the host agreement, it simply does not confer immunity on heads of state. And we quote it in our heads of argument at the foot of page 35. And we submit that the text makes it absolutely clear that its purpose was confined to immunity afforded to the international organizations and their officials who would attend the conference, not on heads of state. Even when it speaks of delegates, it speaks of delegates of certain international organizations. If I may just quote the language as we see it here at the foot of our page 35. The people on whom the immunity was conferred are the members of the Commission, that's the AU Commission, and staff members, the delegates and other representatives of intergovernmental organizations attending the meetings, the representatives of the intergovernmental organizations, and the observers accredited to the African Union. None of those categories include visiting heads of state. All of them clearly are confined to international organizations and their officials.
Well, and is that right? You say that delegates and other representatives are both qualified of intergovernmental organization. But in fact, in Article 8.3, there's no reference to delegates of intergovernmental organizations. It's only representatives. Surely there are three categories. There's the members of the Commission and staff members. There are the delegates. And there are the other representatives.
One I've lost you. Are you reading from
Article 8? Article 8, Part 1. Have you got that? It's at page 83 of the record.
May I just get it?
see, you've read it as being, it says the government shall accord the members of the commission and staff members, the delegates and other representatives of intergovernmental organisations. In your heads, you say that delegates and other representatives both relate to intergovernmental organisations. It's delegates of intergovernmental organisations and representatives. I'm suggesting to you it isn't, that it's delegates separately and then other representatives, and that's confirmed by Article 8.3. Because on your construction, 8.3 would have to read the delegates and representatives.
No, with respect not. 8.3 says the representatives of intergovernmental organisations.
Yeah, but why would you exclude the delegates of intergovernmental
Whose
organisations?
delegates? I submit with respect, let me say this, that if you look at the section under which this immunity was conferred, it is section 5C.
Yes, I know.
It is a section which is confined to immunity conferred on international organizations and their officials. And it stands in contrast with section 7.2, which concerns the conferral of immunity on heads of state. So the starting point is that this immunity is conferred under a section which is confined to international organizations. And we submit with respect that that purpose is entirely consistent with the text, because if I may pick it up in 8.1, the government shall accord, 1, the members of the Commission, that's the EU Commission, and staff members, 2, the delegates and other representatives of international organizations attending the meetings. And then, if I jump to 3, the representatives of intergovernmental organizations and the observers accredited, etc.
It's the second one, Mr. Chengo. I'm sorry, the way I read it in your heads and the way I hear it as you read it, you're talking about delegates from intergovernmental organizations as opposed to delegates to the Assembly. Is that wrong? Have I misunderstood you?
I read it as delegates of intergovernmental organizations.
That's what I thought. I'm putting to you that that's an erroneous reading, that it's the delegates to the Assembly, and then it's the representatives of intergovernmental organizations, and that Article 8.3 makes that perfectly clear, because otherwise 8.3 would have to start with the delegates and representatives.
The difficulty is that one has to take into account the heading of Section 5, which makes it clear that it's dealing with United Nations, specialized agencies, and other international organizations. So it's not dealing with the states or their representatives or their delegates. It's dealing with people who are facilitating meetings of some kind or other.
And just as well as I agree that there is not complete synchronicity between 1 and 3. And in fact, you will see in 3, it also extends to another category, and that is observers.
Yeah.
But under 1, to read delegates as a freestanding category would raise the question of delegates of whom and to what? Whereas the answer, delegates of intergovernmental organizations, gives a ready and seemingly obvious answer to that question. But we do submit that firstly, that it was, the immunity was conferred under a section which is confined to the immunity of international organizations and their officials. And the text is at least compatible with an interpretation which so confines it within the parameters of that section. And therefore that the immunity was limited. Even if we're wrong, this subordinate legislation can't, with respect, in any way contradict or amend.
What do you say about the proposition I put to Mr. Gauntlet that a head of state is not a delegate of a country? A head of state is the country.
Indeed. Yeah.
For these purposes. The delegates are somebody else, but the head of state is the head of state.
Indeed. The delegate is somebody who comes here with a mandate given to him by a principal. So we submit that whatever that interpretation, it also does not advance our learned friend's case. Let me lastly say something about mootness and leave to appeal and costs. The only reason why we did not perpetuate the mootness argument in our heads of argument is this. The order made by the court, which is at page 115 of the papers, of the SCA papers, that's the application, is that the respondents are forthwith compelled to take all reasonable steps to prepare to arrest President al-Bashir. We argued before the High Court that there was no reasonable prospect of him visiting again, and therefore that order had become moot, and the court so held.
The first order is not moot, is it?
I beg your pardon?
The first order is not moot.
No.
It's not of academic interest only, and that relates to the government's failure to comply with the Constitution.
Indeed. That's not moot, but that did, as Justice Wallace pointed out, refer to their past conduct. But let me say, what made a difference was that the government then announced that they were 140 in paragraph 79, and it refers to media reports, of which one is annexed at page 218 of the papers, to the effect that it says al-Bashir gets green light for return trip. Now, once government said that it wished to invite him again, and we couldn't demonstrate that that was not so, one has to accept that the order that they arrest him when he sets foot here is no longer moot. And for that reason, we did not persist in the mootness of it. We do persist in the opposition to the application for leave to appeal on the basis that the appeal doesn't have reasonable prospects of success. The appeal fails on a proper interpretation of Section 10(9) of the ICC Act. Now, whether you refuse leave, whether you grant or grant leave and refuse the appeal is much of muchness, but we do submit that there is a plausible and a reasonable basis upon which we persisted in our opposition to the application for leave to appeal. So we do ask for the appeal to be dismissed and for costs, including the cost of free counsel of the appeal.
Before you pass the baton to Mr. Duplessis, is paragraph 1 of the order, is that appropriately worded? It's painted in very, very broad stripes to say something is inconsistent with the Constitution and invalid. Would it not be more appropriate to say that is inconsistent with South Africa's obligations in terms of sections 8 and 10 of the Implementation Act? Or something of that sort.
Yeah. Let me say that in the on a hot afternoon and an urgent application, this is a commendable order. But with the benefit of hindsight, it can and should be more precisely honed.
And is it a matter of arresting without a warrant in terms of the Criminal Procedure Act, or is it a matter of executing a warrant which has been issued by the ICC?
Indeed, the first warrant has indeed been endorsed by the magistrate and lies there.
Sorry, so there's an extent warrant that has been endorsed by the chief magistrate, well, certainly as far as the first one is concerned.
Yes.
One's not sure what happened to the second one.
Indeed.
Which also, certainly, my little brain, it causes all kinds of confusion because you had the Director General then take this international warrant, have it endorsed. Presumably, one thought that that would be acted upon.
Yeah.
And now you've got government coming to court to say, clear the way for the man to return to the country.
Yeah. It shouldn't have been so. So that you had a warrant that had to be executed. The second ICC warrant had probably also been endorsed by a magistrate. The facts just weren't canvassed in the papers. But what should have happened is that the state should have been ordered to give effect to those warrants and to execute them.
Would it not be more appropriate to word paragraph 2 in that event as not in terms of the Criminal Procedure Act, but in terms of the Implementation Act, to say that these warrants are the ones
Yes,
that...
I think that was an attempt to capture Section 9.3 of the ICC Act, which in turn says that such a warrant must be executed in a manner as near as
possible to the...
near as possible to the, I think it's Section 20 of the Criminal Procedure Act.
And is Mr. Gauntlet's explanation of costs on a pro bono basis correct?
Yeah, what it means is that the lawyers acted pro bono, but there were expenses incurred, and so whatever rules apply when the lawyers act pro bono are the rules that should govern that cost order.
And on appeal? Assuming we're against you?
No, well, then by all.
Thank you. Mr. Duplessis, your leader said that you wanted about 10 minutes. We all keep you to that.
I'll do my very best to keep to that with the court's leave. As my learned leader has already made clear to the court, whatever the state of customary international law, and we know what the position is that our learned friends come forward, it's an absolute position. Whatever that position may be, of course, it's cut past by our Parliament through the implementation legislation. And so Section 232 is the immediate answer to whatever the difficulties may be. But I'm going to just spend the 10 minutes to show you that there isn't in any event an inconsistency, because customary international law certainly permits states to cooperate towards the prosecution of international crimes in international criminal tribunals. There's, in other words, no prohibitory rule in customary international law. And the government's invocation of the arrest warrant decision to push for this blunt and prevailing immunity with respect is wrong. As your ladyship presiding highlighted, already the arrest warrant decision itself appreciated that it was on the cusp of a change in 2002. And we recognize this at page 21, paragraph 42 of our heads, where it was noted that the future International Criminal Court, together with Article 27, was going to provide an opportunity for a gap. It recognized a gap already then in 2002. And for 4 reasons, which will hopefully take no more than 10 minutes, I'm going to suggest that it is wrong not to recognize that the gap has opened. It is wrong to attempt a reification of customary international law, as our learned friends do, to 2002 with the arrest warrant.
I'm sorry, has the gap opened or closed?
Well, the gap has opened in as much as there is a rule in international law which ordinarily pertains to a head of state, and it means that you can't be prosecuted before a domestic court.
But that has changed.
That has changed. So there is a change in the prohibition. And that change is that you are not permitted to do so where you are in an international criminal tribunal, and you are certainly permitted to do so as a state under the Rome Statute, attempting to cooperate with that international criminal tribunal to ensure the prosecution of such a person. And it's therefore wrong to ratify customary international law to 2002. It's also wrong to ignore the developments since 2002. And with respect, it's wrong to ignore the context in which this case is taking place. The arrest warrant decision of the International Court of Justice dealt with one state attempting to assert jurisdiction over the foreign minister of another state. That was what that case was about. It had absolutely nothing to do with an international criminal prosecution by an international tribunal, and it said nothing about the attempt by a state to act, in a sense, as a conduit for such an international criminal court. And 3 months after the International Court of Justice's decision, you have the Rome Statute of the International Criminal Court coming into effect. And you have then a rapid cascading of developments, which with respect need to be taken into account. You first of all have the Rome Statute itself, which in its provisions makes extensive reference to the duties on states to arrest and to cooperate with the International Criminal Court in order to ensure that there is ultimately accountability for genocidaires and others committing those crimes. And we are now at a place in international law where there are 123 states parties, as we stand today, as far as I could check last night, 123 states parties to the International Criminal Court, a very significant number indeed. And the cooperative regime and the duties that are placed upon states parties to assist in arresting is very pertinently highlighted by Professor Clady. It is in our bundle of authorities. I won't take you to it, but it's at page 322 and 323 of SALC's bundle of authorities. And it's also referenced by Professor Akande of Oxford at page 118 of our authorities. In addition to the Rome Statute's provisions itself, of course, then there are a number of implementation acts which are passed by a number of states around the world in order to give effect to these obligations. And with respect, we do need to turn to those in order to highlight that South Africa is in very good company under Section 10.9 of its provisions. If one has regard to Professor Akande, and this is in our bundle of authorities at page 149, and if I might just read it to you, it is in Salt's bundle from Professor Akande's article of 2009 in the Journal of International Criminal Justice. He says the following in the final paragraph on the page. It says, finally, the practice of the parties to the ICC statute suggests that they view Article 27 as removing immunity not only at the stage where the defendant is before the court, that is before the ICC, but also at the national level. Professor Akande says a number of states have adopted domestic implementing legislation which implicitly or explicitly take the view that officials of other states may not be entitled to international immunity from arrest when a request for arrest has been made by the ICC. And this is an article written in 2009. Already there he references in a footnote at that page, at page 19, the following states that have effectively done what South Africa has done through Section 10.9. They are Canada, New Zealand, the United Kingdom, Switzerland, Malta, of course, Croatia, Trinidad, Tobago, Ireland, Samoa, Estonia. That's at 2009. Our learned friends in their heads of argument add two further authorities to that effect, which are against them, which suggest that 10.9 is also done in Uganda and Kenya through their implementation legislation. And then I just would draw to your attention that Professor Akande highlights that section in that footnote, that Section 25 of the Commonwealth Model Law. So the Commonwealth Secretariat has drafted a model law on implementation for states that have become a party to the Rome Statute. And Section 25 of the Model Common Law replicates what we have in Section 10.9. And Professor Akande does that. I see just as well as you're trying to find it, but it is at page 149 of the SALC authorities. Of course, aside from domestic legislation that highlights how Section 10.9 works in a number of other states, we also have the fact that there are ICC decisions and Security Council referrals which have taken place and which the arrest warrant decision could never have taken account of because they all came after that fact. Yes?
This cascading is Disraeli's difficulty with statistics. You say to us that there are 123 states parties as at last night, but unless something happened dramatically, China, India, Russia, the United States are not states parties. And we only need to add a couple of other things to say that half the world's population is not in any way party to or bound by the ICC. Now, which set of statistics should we take as reflecting customary international law? This is of no concern. Britain, I think, is not a party to the convention, but it does have an act to facilitate working with the ICC.
No, it is a party.
Or is it now a party?
Unfortunately, customary international law is not an absolute game, Justice Wallace. We don't need to show that there is universal acceptance. It is a widespread practice. And a widespread practice with respect of 123 states parties out of 190 odd in the world would be suggestive that certainly those states, together with the idea of the International Criminal Court and its regime, recognize that there is, for them and in respect of their practices with each other and the court, certainly an understanding that there is an exception to this absolute prohibition that our learned friends invoke.
Is the fact that we were the first African state to become a state party and to put this into implementation?
We weren't the first state party. Trinidad and Tobago was the first state party, but we were the first African state party. Yes, Justice Vijay, you're right. We were the first African state party.
Surely that's what's important in this case.
It is important because we have a leadership role in that respect, and in other states, certainly African states, have looked to us for that leadership. And it is then a permissibility. It is an opening which permits states to do this. It's not to suggest that the international law rule is now confirmed in this way. It's that there's a permissible exception to the ordinary arrest warrant, customary international law prohibition that our learned friends invoke. And that exception is an exception which pertains to these types of cooperations where states act as conduits for the purposes of international criminal justice to be achieved before the ICC. There's a final aspect which hasn't been in any way taken into account by the arrest warrant decision, and our learned friends still don't properly deal with it. And that is that the arrest warrant case didn't deal with genocide, it was dealing with crimes against humanity and war crimes. This is a genocide case in respect of President al-Bashir, which really is a very important feature of the matter. So in those contexts, there have been developments, and they certainly need to be taken into account. They lead Professor Dugard, this is the second point, to highlight that there is a distinction that one needs to draw when looking at this customary international law rule and whether the arrest warrant decision can be made applicable to this type of case. There's a distinction between proceedings before international courts and domestic courts. And Professor Dugard himself highlights that there have been state practice developments highlighting that where cooperation is requested by an international court, whatever the immunities may be for a sitting head of state or some other senior ranking official, those immunities do not stand in the way of a state cooperating with that international criminal court to hand over for surrender. And we cite those in our heads of argument in paragraph 44. It's enough to highlight the Milosevic example and the example of Charles Taylor. The third point, very quickly, is that our learned friends suggest that there's no authority that they can find which suggests that a domestic court has ever done this. Well, there is. The Kenyan courts did it in 2011. Of course, there is an endorsement, at least, of an arrest warrant, as Justice Pono highlighted, by a South African magistrate in 2009, which has never been set aside. The government has never disavowed it. It stands. So we have certainly seen developments taking place, and they're developments that are consistent with the Rome Statute's views of attempting to ensure accountability for these types of criminals through the cooperation of a domestic regime with an international criminal court regime. Fourth point on this, and the final one, is that, of course, one has to recall that in any event, the arrest warrant decision by the International Court of Justice involved states other than South Africa. It was Belgium and Congo. And it's not binding on, this court's not binding on South Africa in two respects. It's not binding at the international level, because Article 59 of the Statute of the International Court of Justice, and Justice Wallace, we will make that available as well to the court when we hand up the provisions that may be of assistance to the court. But Article 59 of the Statute of the International Court of Justice says the decision of the ICJ has no binding force except as between the parties and in respect of that particular case. And Professor Crawford, writing in the 2012 edition of really what is probably the leading international law book in the world, Brownlee's Principles of International Law, at page 60, says this. He says, the decision of the ICJ, even one concerning substantially the same issues before a national court, does not itself create a res judicata for the latter. So it's entirely open to this court to decide what it thinks is the current state of international law. The ICJ's decision is certainly not binding on it. If there was any court to which Your Ladyship and her brothers were to look for guidance as to the gap in customary international law that has opened up and which permits states to cooperate with an international criminal court in arresting a head of state even though he has immunity ordinarily under international law, where better to look than the International Criminal Court's decision? My learned leader, Mr. Trengrove, has already highlighted that wasn't a decision made somewhere late at night. It was made by the pre-trial chamber of the International Criminal Court. It was made referencing previous decisions of the International Criminal Court. And it is an International Criminal Court decision in respect of South Africa. It is the International Criminal Court decision in respect of South Africa in relation to this very accused. And it is an International Criminal Court decision in relation to this very accused that the International Criminal Court says no longer has immunity because of a Security Council resolution, emphatically. So to the extent that there's any guidance to be sought, Justice Wallace's question earlier to Mr. Gauntlet, where is customary international law sourced? The answer correctly by Mr. Gauntlet was, well, one looks to international tribunals. Absolutely. The one in point has to be the International Criminal Court's decision, the one rendered against South Africa on the 13th of June last year.
It's not for this court to run ahead of international tribunals. It's not for us to sort of become path breakers, is it?
Not at all.
Because that's not what the Constitution says, that international customary law is part of our law. It doesn't say that we're to go out and make it.
Absolutely, but fortunately, this court is in the happy position of not having to do so, because the expression of what customary international law is in this case, in this context, in respect of this accused, in relation to this country, has already been made by the International Criminal Court. It has said in a judgment that there is no customary international law immunity that bars South Africa assisting in the arrest of President Bashir and surrendering him to the International Criminal Court. That is where one looks to for an understanding of what the gap is in customary international law with respect. So the government, to try and round off this point, I appreciate 10 minutes is growing rapidly, but the government makes the mistake of treating customary international law as both static and blunt. As we've shown, whatever it was in 2002, it's moved on. It has moved on under the weight of rapid developments through the International Criminal Court, through the Security Council's resolution, and it has done to, ultimately, the effect of trying to hold accountable such individuals. It's also not a blunt rule. As we say in our heads of argument at page 26, paragraph 49, again with reliance on Professor Crawford, now Judge Crawford of the International Court of Justice, immunity exists as a rule of international law. Sure, we accept that. But its application, says Judge Crawford, depends substantially on the law and the procedural rules of the forum. Here, if you stack up what those procedural rules are and the forum, we're talking about the South African ICC legislation. We're talking about the Security Council resolutions in point. We're talking about an ICC decision against South Africa. Those are the stacking up factors which tell you what the application is of the otherwise blunt rule of international law that our learned friends would seek to invoke.
So you're saying there's been a process of development of the law relating to immunity, somewhat similar to the process that occurred with commercial immunity until, 1918, 1920, courts wouldn't touch an asset owned by a foreign state. But then over the next 40 years, when foreign states started to engage in trading operations, they started to say their ships could be arrested, their trading activities didn't fall within immunity. You say this is a similar progression that's occurring in regard to international crimes.
Yes, Justice Wallace. I mean, Lord Denning in Trentex started that movement towards the commercial exception. We are seeing precisely under the weight of international criminal law, the Rome Statute, the state practice that goes with it, the arrests that have been issued by the International Criminal Court, and the judgments by the court, we see precisely that development.
But it dates back to Nuremberg, originally, because that's the first one.
It does go back to that, yes. So there's one final impact on this understanding of customary international law, which I'll finish with, and that is the weight of the Security Council resolutions. Justice Majid, I think, raised it first. It's this question that we are dealing with a case before the International Criminal Court that got there by virtue of Article 13b of the Rome Statute. The court gets jurisdiction only over states parties, or by the prosecutor deciding to open a case, or by the Security Council referring a situation to the court where it is a situation in a non-party state. That's how Sudan, as a situation, got before the International Criminal Court. And when that Security Council Resolution 1593 referenced the genocide and the situation requiring, ultimately, the International Criminal Court's attention, the Security Council did so under Chapter 7. Those are unbelievably powerful powers. Chapter 7 of the UN Charter allows the Security Council to use all necessary measures, in code language, for force, to invade. Or it can create international criminal tribunals, as it's done in the International Criminal Tribunal for Yugoslavia and Rwanda, or as it's done here, sending a case to the ICC. It does so because it recognizes that these types of situations are a threat to world peace and security. It's not a trifling matter. And we know from the arrest warrant, the second arrest warrant in respect of genocide, that that arrest warrant suggests the genocide with al-Bashir in power is a genocide that continues. It's not past conflict. It's a genocide that is continuing. Our learned friends of the amici will pick up that point further. So it is a vitally important moment to realize that there is this Security Council resolution. And in the scheme of the way that the Council works, it has effectively made, for the purposes of the way that the statute works, it has made Sudan a party to the Rome Statute. It has done so. It has the power to do so through Chapter 7. So all the provisions of the Rome Statute are now applicable to Sudan, including Article 27, which says you have no immunity. Sudan is therefore, for purposes of the Rome Statute, as though it were any other state, and its head of state has no immunity before that court. That's what the Security Council Resolution 1593 has done. Our learned friends for the government attempt to get round this point, and they do so with reliance effectively on one academic. In their heads of argument at page 36 paragraph 68, they rely on a Mr. Kiani. There are 4 problems with this, with respect to them. The first point is that Mr. Kiani is something of a dissident and lone voice. His article appears in the Chinese Journal of International Law. The second is, in the abstract of his article, he says that contrary to most commentaries. It's important to me that may be a contradiction in terms. I'm not saying anything further, but he does say, Justice Bonan, he says, in his own abstract. I'm just being facetious. I'm not taking it further, but what he says is contrary to most commentators. These are his words about his own article, which they're referencing as getting round the Security Council resolution quandary for them. His own article says that contrary to most commentaries, this essay argues that Bashir remains protected by head of state immunity. So he is a lone and dissident voice. And Professor Clady notes, at paragraph 54, page 29 of our heads, we've referenced him, that this lone dissident voice is entirely contradicted with respect by the great and the good of international law. We reference them at page 29 of our heads of argument. There's Professor Akande, who's a professor of international law at Oxford, and with respect, he's the leading writer on this area of immunities in the law. Professor Slater, Professor DeVette, and...
I'm afraid I've never set much store by counting academic heads.
Well, let me then finish with at the very least highlighting that without counting her, but putting her forward with respect as the leading authority on immunities, a recognized immunity authority, quoted extensively in the Pinnister judgment, Lady Hazel Fox QC. And that was what I registered in Chambers, Your Ladyship presiding, was the authority that we'd wish to hand up to the court. It is, I think we've got the copies here, if I may hand them up. The only reason we're handing it up, well, there are 2 reasons. The one is that Lady Hazel Fox QC is the recognized doyen of the law and immunity. The second reason is that, for reasons which are related to the pace at which we were preparing, we were only able to get the latest edition of her book recently. And the latest, the 3rd edition of her book is 2014. And I would simply draw your attention to page 558 of her book, where she says, this question has arisen before the ICC in the context of an arrest warrant for the incumbent president of Sudan. The pre-trial chamber held at Custom International creates an exception to head of state immunity when international courts seek a head of state's arrest for the commission of international crimes. The fact that the situation in Darfur was referred to the ICC by the Security Council pursuant to a Chapter 7 resolution is significant, she says. According to Articles 25 and 103 of the UN Charter, so we might add those to our bundle when we give them to you in addition to 48 and 49, Articles 25 and 103 of the UN Charter, member states are obliged to carry out Security Council resolutions even if they conflict with any other international agreement. The removal of immunity in this case is thus a function of the Charter law operating in a specific situation. She says that even though the pre-trial chamber did not use this argument in its decision, in other words, this is her argument, but now you know that the pre-trial chamber that she's referencing is the earlier decisions. We've now got decisions of the ICC pre-trial chamber, including one binding against South Africa, where they say specifically that the Security Council resolution has then removed the immunity. We then come finally for me to just conclude by saying we submit with respect that customary international law does not assist the government in this appeal. But as Mr. Trengrove has explained, whatever the state of customary international law, whatever the debates may be, for this appeal, the International Criminal Court Act that South Africa adopted trumps through Section 332. And our Parliament has cut its way past this controversy. Section 10.9 really is the easy answer to the case. But to the extent that you wish to interrogate customary international law, then you can do so safe in the knowledge that there certainly is a gap that has opened up for precisely this type of example, to hold precisely this man accountable, and in respect of a decision which is against South Africa by the tribunal that wants its hands laid upon it. Thank you very much.
Thank you. Yes, the court will take the lunch adjournment now, but we will resume at 2 o'clock, not 2:15.
Didier Drogba, a footballer from Ivory Coast, was named